Good evening. This is a meeting of the Fairfax County Wetlands Board. I'm calling the meeting to order. Catherine Herman, our staff member, would you please call the roll?
Sure. Sorry, one second. All right, Brian Campbell. Absent tonight. John Collins.
Present.
Dean Costello.
Present.
Bert Kramer.
Present.
Kim Morgan. Present. Steve Chappelle. Clyde Wilbur.
Very good. Quorum.
Yes.
We do, very good. So the first item on the agenda this evening is a restoration order for 10625 Green Drive in Lorton, Virginia. First, I'd like to ask each of the board members to give any disclosures or recusals for this particular meeting tonight on the restoration order. Hearing none, we'll move on to the staff report. Catherine, would you please go through the staff report for us?
Sure. All righty. Thanks, everyone. I'm just going to do a brief overview on the slides. Before I do that, let me turn off the lights they're going to go off about 75%. If you need them turned on, please just let me know and I'll turn them back on, but that way you'll be able to see the screen a little bit better. So the location of this property is at 10625 Green Drive in Lorton, which resides on Macy Creek, where the red dot is shown. Oh, my goodness. Sorry about that. Oh, it's going the wrong way. Hold on. There we go. Stemming from a complaint on June 21st, 2021, the Wetlands Board Chairman issued a stop work order for impacts to tidal wetlands without a permit. The sworn complaint letter and stop work order letter documenting those activities on the property constituted a substantial violation. On August 10th, 2021, a show cause hearing meeting was held where the Wetlands Board heard information on the work completed from the applicant and their agent. During the applicant's development of a joint permit application, VMRC and the Virginia Institute of Marine Sciences, VIMS, and Virginia's Department of Conservation and Recreation and their Shoreline Erosion Advisory Service staff visited the property on September 8th, 2021. Based on the site visit, VIMS and Cs concluded that there was evidence of a vegetated wetland on the landward side of the new bulkhead. The observed wetland plants is included as a defined vegetated wetlands under Virginia code and therefore classifies the shoreline at this property as vegetated wetlands. VIMS and Cs also prepared a field report after this site visit summarizing their findings and recommending design considerations. This report was sent to the applicant and the agent on September 23rd, 2021, and the report included recommendations on stabilization techniques such as integrated low sills that could tie back into the bulkhead and a man-made boat slip, and that the adjacent property to the south and included information about the adjacent property to the south and other components of a living shoreline. At the time, county staff, the applicant, VMRC, or since this time, I'm sorry, county staff, the applicant, and VMRC have collaborated on various resubmissions of the JPA. After the Wetlands Board approved an initial permit application during a public hearing on March 6, 2023, the applicant stated in email correspondence that they would not sign the approved permit. The applicant appealed to VMRC and later withdrew that appeal. During the site visit on April 10th, the county and VMRC observed several tidal wetland plants on all three sides of the boathouse and on the northern and southern portions of the bulkhead, specifically dock, smartweed, and sweet flag. The identification of these plants landward of the bulkhead in several locations along the bulkhead demonstrates that this site has vegetated wetlands along the landward side of the bulkhead. During the public hearing on June 13th, 2023, for a second permit application, the board asked the applicant if they would agree to sign the approved permit from back in March 2023, which would include modifications that would bring the project into compliance with county code. The applicant indicated that they would not agree to any modifications of the permit and continue to not want to implement that approved permit. The applicant's engineer of record stated that the previously approved permit was feasible to construct. During that public hearing on June 13th, the Wetlands Board members voted to deny the second permit application. One last thing to note is that the first time the design showed the Wetlands Board full complete jurisdiction at the property, which is up to 1.5 times the mean high water line, was after the June 6th public hearing. All previous permit applications did not include this critical data set. And then I just have a few slides here to show a comparison of historical Fairfax County imagery showing the status of the old bulkhead that has since then been replaced. So in 2007, it appears to be intact. And then in 2015, there's photographic evidence of the bulkhead or a overtopped bulkhead. That's what those 3 images on the right are showing, just zoomed in. These series of photos here are just from a site visit in April 2023, just to show the current status of the property. I'm not going to read this slide, but essentially what it is this is from the June 13th, 2023 public hearing, where the second permit application was denied and the Wetlands Board voted and approved this decision, which is the request for a restoration order meeting to be scheduled. In my staff memo, I included a few considerations that the Wetlands Board could consider when discussing this matter tonight. This is not an exhaustive list. It's not all of the options. I found it to be maybe the most feasible. So the first bulleted item is the removal of any structures installed after 2015. Another option is, or could be in addition to creating areas to the north and south of the boathouse walkway to obtain minimum vegetated wetlands and the square footage, which I can speak to in a minute here. Don't feel like you need to write those numbers down. And then also a citation with the Virginia Code on how tidal wetlands areas must not impair natural functions of vegetation or alter the natural contour of the wetlands. Again, this is not a complete list. This is a set of considerations, not considerations, potential conditions that could be carried forward as part of a potential restoration order. Again, not an exhaustive list. Just also, these are some things that the Wetlands Board and or myself as the staff liaison have communicated or included in previous permit conditions that we've seen in the past. So these, I don't believe would be new information. And then I believe this might be my last slide. It is something that we can use as a reference. This is from the most recent submission that we received as a new proposed design from the applicant and their agent. The reason why I wanted to show this, while we are not here to talk about the current draft submission that has been provided by the applicant in recent weeks, because we're here to talk about a restoration, I actually found this graphic really helpful. So what I did is I took the graphic and I just added different colored lines over top of the engineer's lines so that we could visually see them a little better. The green line is a mean low, it's the mean low water line. The yellow line is the mean high. And then the orange line is the 1.5 times the mean high elevation. And then there are some, I didn't realize this was so blurry, sorry. There's some calculated wetland square footage area tabulations there on the right that are points of reference that could be referenced during your discussion. And I'd be happy to help you refer to them if you need to. And that's all I had.
I'd like to move to the consideration for the contractor charge, which is included in the staff report, which recommends a civil charge of $10,000. Do I have a motion for that?
We're going to make a motion for discussion.
A motion for discussion. No, we have we discuss a motion once it's moved and seconded.
I move motion to approve the recommendation of staff report with respect to the contractor and issue a civil charge of $10,000.
That's right. Now, open for discussion.
One of the axis in that matrix was impact. And the impact seems to be limited to the effects on the wetland, not the severity or repeated or willfulness. I may be misunderstanding that. That all seems to fall under significance, not impact. And my understanding is that vegetation was found in somewhere between 2 and 5 locations. It would seem to make it very hard to justify a high impact. Maybe I'm misunderstanding the criteria.
Any other comments?
I'm referring to the criteria in the
Pull up that
staff
form.
report. There was a matrix.
Oh, you're
where-
talking about the significant moderate.
Correct.
Got it.
Sorry, give me a second.
And so one of those axes, if I understood correctly, seemed to be was it repeated, willful, was there a history of non-compliance? All of those can increase the severity, I think is the term. But the impact seemed to be limited to what was the damage done.
So we're talking about a form that comes from DMRC. We'll pull it up here in a moment.
Yeah, sorry.
Take your time, it'll go faster.
It's like trying to look for the most obvious button. Okay, so I believe Mr. Collins.
And
Yeah,
yeah,
you make this a little bit better so we can
I
all
think
see.
there was an explanation beneath that.
yes. So you're questioning the significant?
I'm questioning the
Okay, I'll keep scrolling. You tell me.
yes, impact factors.
Okay.
So there are, so would you move this to another level of impact?
I think that for this particular case, it would be hard for me to justify it from above moderate. And I would argue perhaps minimal, because my understanding is there were only between 2 and 5 fuel plants observed. So I wouldn't understand what would constitute minimal if 5 is considered.
So if I could suggest, for us to consider this, you have to make a motion modifying the motion on the table.
I would make a motion to move this to.
So the motion stands, is there a second for this one? No second, the motion fails.
Mr. Chairman, finding that
No, you may not.
the contractor is here.
You may. The meeting,
I
not a
understand.
public hearing.
So we're not having a vote.
No, it's the meeting. You may have statements if you want.
So you intend to act without comments, in which case I object that there's a lack of due process in this meeting, Mr. Chairman. I object strenuously.
I can just do that as opposed to the meeting.
I will also do that in court if necessary, Mr. Chairman.
Moving on. Any other comments on the motion before us? And I'd like to call the question. All those in favor of approving the staff report recommending a $10,000 fine to the contractor? All those in favor, please say aye. Aye. All those opposed?
Nay.
We have, I'm sorry, I need to count. We have 5 for and 1 opposed. Is that correct? Correct. Can you record that, please?
Yeah, 4. Yeah.
No, I
Oh.
think we're not.
You abstain, okay. 4 in favor, 1 abstain, 1 opposed. And we need to record the names for this, so Catherine, you please record the names if we did want.
Yes. So I'll just call them out. The members voted to support Clyde Wilbur, Dean Costello, Kim Larkin, Stephen Chappelle. The members who abstained is Bert Kramer, and the opposition vote is John Collins.
Thank you. The next item on the agenda is the consideration of the restoration order. Do we have a motion?
I'm getting discussing it. I move a motion to approve the recommendations in the staff report and issue a restoration order in accordance with all aspects of the staff report to the property.
Do we have a second?
Second.
Okay, discussion. So we can do this one of 2 ways. We can just take questions back and forth to discuss issues, or we can go line by line through the staff recommendations. I'm sorry?
Is it possible?
Well, if we go line by line, so if anyone wants to go through line by line, I will do that. Does anyone want to do that?
Well, there's a lot of options in there.
No, they're not options. Well, yes, there are.
There are options.
Do I have a consensus that we want to go through line by line? I need some reaction.
Yes.
Okay. All right, let's go to the staff report.
Before we jump into that,
Sure.
one question that kept coming up to me is the extent of the wetlands. Is it possible to pull up where these plants were found? I know that that was in one of the reports, but I could not find exactly where that was.
So this is part of the issue is that it was under construction before we ever got on site.
Yes, I do
So
remember that.
there was a lot of disturbance on site prior to them being out there.
My recollection is when they got out there, there were 2 locations where they set out smart.
I don't have that in control.
But as I was going through and reading the discussion on mean low, mean high, times 1.5, it did not seem clear to me that that says the entire plat within that boundary along the plat line becomes tidal wetland. it's not concerned with plats at all, it's concerned with the area around the vegetation. So it seems actually very critically important to identify, is the jurisdiction the entire property, or is it an area north and south?
If I could speak with the staff report, the answer is yes. The staff report states that the entire jurisdictional area, which is 1,247 square feet, is vegetated tidal wetlands. That's what's in the staff report. It's what's supported by VIMs and observations by wetland board members on the site. So I'm not saying we can disagree, but to do that, you have to, well, you can disagree. But the staff report takes that position. It's supported by VIMs, and it's also supported by observations by wetland board members in the field. In addition, I would point out that there is one other issue here, and that is that the property was disturbed during the construction. So it's quite possible that there were even more wetland plants that were destroyed by the construction. So I'll leave it at that. I personally believe in the staff.
And my intent is not to disagree, I just want to make sure I understand, and I'm applying it correctly, because it doesn't seem sensible to suggest that the wetlands just ends at a plat line, because the Virginia law in question does not mention plat lines, it mentions the vegetation.
What line?
Is that
Flat.
plat lines?
I don't know what you mean by that.
The property line. The law in question doesn't say it goes from property line to property line, it talks about the area around the plant. And that's why I'm wondering where the plant's found, because that's where the jurisdiction.
Catherine, can you pull up the drawing you sketched of the jurisdictional land?
The one with the different colored lines.
So this is based on the engineer's submittal. And the brown line is the 1.5 times mean high water mark approximately. And the green line is the mean low line. And in addition, it's kind of hard to see, but on the right-hand side, the square footage of mean high to mean low is listed at, can you read it, 533?
533 square foot.
Right, and the jurisdictional wetlands between mean high and 1.5 is 714.
If I'm understanding though, that calculation is based on the guidance that the mean load 1.5 feet high was what constitutes the vegetative wetlands.
So you're asking where were the plants found?
Correct, because the Virginia law in question simply states that the vegetative wetlands is the area around where the plants are. It doesn't extend up and down the coast indefinitely. It's within the area where the plants are found.
The plants were found on the south side of the bulkhead and later observed on the north side.
So they should not cover the boathouse, if that's the case.
But they could, I'm sorry, I have to disagree. The jurisdictional area is the entire area.
That's not what the Virginia law says.
All right, so do you want to make a motion?
You know, I would like to see where the vegetation is. My understanding is one of them is pointed out in the corner there, and I believe the other one is in the middle of that bulkhead.
There was only one spot.
All right, please, wetlands board members on.
2 minutes.
So, John, I don't know what else we'd like. We have the VIMS report saying that it was a vegetated wetland. We have the jurisdictional rules that say 10 to 1.5 times. I personally have observed vegetated plants all around the area. Would you say something for the record?
Also, so when I went out there, there were wetland plants on the southern beach of the bulkhead and on both sides of the lake. But again, when Ben went out there, it was a mud puddle, excavated area that was no way to determine where plans were. Was violated. If this had been an application, we would have, it would have had a delineation in it prior to application.
Can you go back?
I understand that.
I do want to satisfy John to the extent we possibly can. Can you go back to the historic photos, please?
I'm not trying to be a pain here. I just want to make sure
No.
that I correctly balance the interest in safety.
Yeah.
Don't overextend.
Sorry.
Go back to, yeah. If you notice, you can see that there is obviously a tidal wetland area landward of the bulkhead. I think this is a 2015 aerial.
Yeah.
It's now 2023. There have been 8 years for vegetation plans to develop in what would be a natural environment for a vegetated wetland. Now, we couldn't observe it because it was dug up. But certainly on that entire south side, that is the case. Now, more difficult to see, but if you look on the south side, you can see a gap between the bulkhead on the south side and the land side. Also an area where the vegetation could develop. We don't have all of them, but there are additional photographs close to the boathouse indicating that there was similar muddy areas on either side of the boathouse. Now, these are just photographs, but I think the real point, John, here is that this really is an area where a vegetated wetland was allowed to develop, at least for a period of 8 years. And if I could point out, it is our job to protect vegetated wetland in the Commonwealth.
Yeah, I understand that. Would the argument be then that the vegetated wetland extends to the properties on the other side as well?
On the other side, yes.
Where would it end? Is there a rule of thumb that's being applied here? Is it 100 feet, 50 feet?
The jurisdictional area of the wetlands board is to 1.5 times mean high water.
I mean along the water. How far down do you
Mean low water to 1.5 times mean high water.
go across the entire creek?
No, mean low water, where land is exposed to mean low water.
I'm talking north-south. Yeah, I'm talking south. I'm not talking about, where does it end? Does it end at the first flat line?
So theoretically, if you look at the land to the south, you see a bulkhead, right?
Yeah.
If theoretically, mean low and mean high was entirely along that bulkhead, there would be no jurisdictional wetlands. But if the creek bed is exposed at mean low, there are jurisdictional wetlands on the water side of the bulkhead.
Hi.
Yes.
If you would like, I can read the definition of vegetated wetlands out loud. Okay, so from the Code of Virginia, vegetated wetlands means lands lying between and contiguous to mean low water and the elevation above mean low water equal to the factor 1.5 times the mean tide range at the site of the proposed project in the county, city, or town in question, upon which is growing any of the following species, and that's the long list of species.
effectively be assuming to mean the property impact.
Well, it's the area approximated by Chapman's sketch.
Again, it says those components at the site of the proposed project in the county in question.
You should go to your sketch once more.
Oh, sure.
Green to brown. John, I'd like to continue on. If you need to come back to this, we certainly can.
No, I think that's fine.
All right. Let's go to your staff report.
Yeah.
Bring it up.
Mhm.
And your recommendations.
Okay, so considerations.
Any discussion for items 1 through 3?
Let me zoom in.
Structure have been installed after 2015 and needs to be everything present right now. Is that correct?
The 2015 date is based on the photographic evidence, and basically the photographic evidence. There are photos going farther back,
Right.
And eventually you get to the point where the north bulkhead is cracked. So
The 2015 just updated on the photo that is
in the record, and a part of some of the original applications. Hearing nothing about this, can I move on? I'm going to go to the next list, the additions. Many of these are from the 1991 enforcement guidance from UMRC. Not exactly, they're more tuned to what's here. I think staff has gone through and chosen a number of things. I would point out that item 4, within 120 days, we're looking for the provision of a signed contract for a wetland plant professional. Wetland plant professionals can be called for under the 1991 guidance. Also for the provision of a letter of credit. In this case, staff suggests a $5,000 letter of credit. Finally, to pay a civil charge of $9,000 to Fairfax County due no later than April 1st, 2025. And that late date is provided to allow the applicant to resolve all these issues, not have to go through a restoration order, I hope, and actually have an approved permit. And if they do get an approved permit, this is my personal suggestion, I think the Wetlands Board could consider waiving the civil charge. And that's the reason for making the date. Bottom line.
So go back to number 1.
Sure.
Sorry, I just had a question about,
Items 4, 5, and 6 are pretty standard language in our typical permit, just included here in the restoration order.
Or C, that's based on that matrix we saw earlier.
Yes,
It's on moderate, which is not considered willful, but it was considered high impact.
let's take a look at the staff. So The encroachment is the same. You want to go down to why it was a lesser. Which one? Yeah, keep going. Yeah, go up.
Yeah, sorry.
So the explanation for it being moderate is
Not the moderate, high impact.
the high impact. The high impact is the same as it was in the contract evaluation.
Why, there was no discussion on that, I didn't understand why that was. I was kind of looking for feedback on that. Has large encroachments, but I guess I understand what constitutes moderate. Again, I might be wrong, but I appreciate any discussion.
Right.
Is there any particular reason why moderate has the qualifier on limited inclusion? Considering the different order with?
I think a part of this is that the Wetlands Board and the staff established this as a significant impact in the original stop work order. So the stop work order takes the position from staff and the county, and frankly, from me, by scientists, that the impact is significant.
I was curious about that.
Yeah, I'm afraid I don't have any additional guidance from, this is a PMRC form. There is a much longer discussion in the 1991 guidance document. I would point out that these numbers are from 1991. The dollar amount have not changed. Correct. And again, I would stress for the applicant, if this is resolved, I personally would bring to the board suggesting to drop this. I hesitate to interpret what's in the 91 PMRC guide, but I think it's clear that this is really something that's done to encourage action and avoid going forward. And it's really not, in my personal view, to be punitive.
It sounds like the intention is that this should, even if it should never come out, because hopefully, and I get that, but I would still like to make sure that whatever order we're moving on is meeting with the definition. And it sort of seems like significant is intended to be they're dumping oil into the waterway, not in a scenario. So that's, is it just that there was excavation along the entire bulkhead? What's making this significant?
I think that the statement, first of all, that was stated in the original letter, but if you read the explanation there, it also indicates that it's significant that it remained in place for more than 28 months.
Yeah. Then under this significant effects on loss of bottom land also.
I would interpret that as opposed to me. So let me ask the question, does anyone want to change the staff proposed civil charge?
I would argue that whether land not owned by applicants is a big thing, but it's not relevant to the impact as discussed here.
Can you make a specific motion?
I thought it was a discussion.
We are, but I'm kind of asking. Can you make a specific?
Yes, I was looking at specific motion.
Is that case after the apartment transfer now?
It's no longer on property not owned by the applicant. We're going to swiftly to adjust that. I don't actually view that as past due at all. 2 years because of the stop work order and a disagreement about how to comply. I think that falls under severity, which talks about whether willful or is it not compliance. This is to be addressing very specifically the impact on the wetlands, not legal matters, not disagreements, not.
Yeah, but the argument can be made that because the wetlands that were most likely there as a result of what was found were disruptive, and so that seems like that would be critical.
All right, hold on a second. I mean, this is fine, this should go on, but for us, we can discuss it, I need a motion. So you have a specific motion to change the staff's proposed civil charge.
Not yet.
Okay, let's go on.
I would need to continue discussion with the current proposal in order to make a motion to change it. I can't give you a motion until I've understood it.
We have a motion on the table to approve the staff report as written.
I understood there was a line by line discussion going on.
There is. But now at this point, either we change it or we don't.
I'm intending to issue a motion to change it. I don't know at which level yet. I would be in favor of minimal or moderate, but I'd like to understand that there's a reason that it should be moderate rather than minimal.
I think at the moment, the staff report explanation is quite simple. One, it was established as significant during the original letter. You take that or leave it. And the violation was remaining in place for 2 years. Construction proceeded on property not owned by the applicant. That's the rationale from the staff.
I understand that. Are we not permitted to discuss?
Sure, absolutely.
Okay.
Let me turn it around to you on this. Why think it should be minimal or moderate instead of
Because I'm understanding the impact to refer to the level of damage to the wetlands. And all the rationale issued in the staff report seem to speak to matters unrelated to that volumes there.
in the structure of wetlands or constructions significant enough to be able to hire the grade?
If that were the case, then every incident would always be significant. You would never have anything more mild. It seems, especially considering inflation, what that number would be today. Significant is intended to be for severe cases, not homeowner does something and then there's a dispute. And we're talking about a couple of instances of smart weed, and they seem to be continuing to establish themselves just fine. And there was grass there before. I'm not seeing an argument that this is gross damage to wetlands. I think that you could argue that perhaps a charge is warranted due to non-compliance. I don't think you can argue that. We're talking.
Sure, it's more of a semantic scheme at this point, in that you aren't really defining. 800 square feet is moderate. 801 square feet is significant. I know that's 714.
The law is not specific, that's true. I'm trying to do what it feels like the intent is, and it feels like the intent is too significant for, there was some pretty serious damage. It seems like you would expect moderate or minimal to be more. And I would expect cases like this to be more for when we're doing restoration relation to the someone has done some work that was unpermitted. You would expect to get a case like this. I wouldn't expect it to be significant anytime. So I would argue for moderate at most. I think limited encroachment to more with some effects on vegetative plants. I think that makes sense. There's not a lot of vegetation.
If I could, I'd like to do a little poll with anyone other.
I'm not
Sure.
It's significant in relation to this parcel. It's not in the global spectrum of what it's the big picture of Chesapeake Bay. It's like one problem due to this work. That's why it's a big deal. Because wetlands presently have been.
So like 714 square
It
feet.
does, I mean, that smaller parcels to get significant much easier, which doesn't seem like the intent. The intent here seems to be the waterway, which is not
can be hopefully refined, no, right?
I would recommend a motion to change this in moderate.
Do a second? Hearing no seconds, motion fails. We'll go on to the next item, please.
Oh, sorry.
Go back.
Sorry about that.
The options.
Yep.
So 5, 6, 7, 8 are pretty standard language. Does anybody disagree with or want to discuss the April 1st, 2025 completion date?
You know that, Jeremy?
It gives them plenty of time.
Okay, just, it's turning date without. Okay.
It's like roughly 18 months.
18.
Hopefully it'll get out. Go ahead.
For number 6, would it be worthwhile adding a notation that a member of the Wetlands Board be at that meeting?
If you wish. I think you could do it anyway.
Oh, okay.
A member of Fairfax County staff.
Mhm.
It's in there. Will be held on site.
I figured that was Katie or Katie-ish.
Right, I understand.
Yeah, but certainly if you want to attend, I'm sure that would be okay.
Okay.
Okay. Let's move on. Catherine, can you do something? So this also indicates that we're approving the idea that the Wetlands Board is still open to an application. Is there anything else in here that we're approving, Catherine? That's it, right? I would like to discuss one possible addition to the staff report. I'd like to suggest that within 120 days, it should be time to hire the wetland specialist. If an in-person meeting be conducted between the applicant, their engineer, their contractor, and their wetland specialist to try to resolve any issues. We'll do that as a motion.
Is it worthwhile adding the arborist to that list?
Let me make a motion. I should have done that. I move we add to the staff report and recommendations that within 120 days of this restoration hearing, that a meeting be held with the applicant, their wetland specialist, their engineer, any other individuals they wish to invite to the meeting, and staff to try to resolve issues going forward. I have a second.
Second.
Discussion.
What's the intended output of this meeting? Or is it just one ongoing thing?
It's intended to get everybody in the room to figure out what's approvable and get past. We have easily over 100 documents in the DMRC record. Typically, for a regular permit, we have 10 or 12. Okay. We got to get in a room and knock this out.
So there's not a required output. This is to just grease the wheels and go.
Clearly, the sending documents back and forth is important. On my understanding. And I think, at a minimum, the applicant, the engineer, and the wetland specialist.
We need to add URC.
I think that the staff attending the meeting can be anybody from the county or BMRC or NIMS, that can make it. I don't control BMRC or
Right.
NIMS budget. I don't think I could put an order in to the applicant that orders somebody not there. You can.
Right.
So. Call the question. All those in favor?
Aye.
Aye. That's unanimously. Did you get enough of that?
Mhm.
Okay. Any other discussion?
Any additions, maybe?
Yeah.
That's all, right? And, yeah.
Yeah, that's it. Hearing more discussion, I'd like to call the question. All those in favor of approving the board, the staff report, the issue restoration order with the modifications proposed herein, please signify by saying aye.
I'm gonna make a recommendation, certainly allow the property owner to trust the board for making a decision on the company.
If the county attorney thinks we should do that, we'll absolutely do that. We have someone who will represent the county, only here tonight. Please, can you state your name for the record?
Craig Linkley, Alliance Law.
Yeah. We swear to tell the truth, the whole truth, and nothing but the truth. All the truth.
I think the discussion that you just had would have benefited our input and came perilously close to violate state statute, which requires that the restoration order be issued only after a year. I'm sure you're aware of that statute, Mr. Chairman. If you aren't, you should be. Your attorney saved you from perhaps a serious mistake. The report that was given by Katie Kern, I think, creates a very false impression of what our clients have done. First of all, I was newly engaged, so I'm not immersed in the details as you all have been. But I have tried to get in touch, get on top of the issues. And I think it's fair to say that the 2-year period that you're talking about here has been punctuated by diligent efforts on the part of the SANS to comply with your requirements and with the specifications of Katie Berman in trying to enforce your will. I would like to pass on to you, and for the record, my prepared comments. I don't know whether you want them or not, but I will pass them out. I would note for the record that there was a third permit application, which Ms. Herman did not note in her report. It was submitted in September, and she issued a letter on October 5th, basically saying it was incomplete because they hadn't met the requirements that she thought should be present in that application. As I understand it, there has been a repeated conduct throughout this entire proceeding of Ms. Herman and others indicating applications were incomplete, when in fact they were complete. But apparently the use of the word incomplete is intended to avoid triggering the 60-day clock under which you must act with respect to a completed application. One was submitted in September of this year, and I'm going to call upon, as part of the applicant's presentation, the property owner's presentation, I'm going to call on Jim Beck to explain the errors which we believe were made in Katie Herman's analysis of the application. I will say that in that third application, we've tried to mitigate the post-construction wetland that were created by their inability to work on the bulkhead as a result of the stop work order. It's important to note that in order to reach a resolution of this matter, we would prefer not to go to court. But we do not concede the board's jurisdiction extends onto their property. We believe the board's jurisdiction is limited to that which existed prior to the construction of the bulkhead, and that they have the right to repair and maintain the bulkhead as is provided specifically in section 116-1.3, paragraph 9 of the Fairfax County Wetlands Ordinance. And I would note that the corresponding state law actually is cited by Katie Herman in her report in point 3 under the restoration order. So it's puzzling to us why she could cite the ability to preserve and restore existing bulkheads, existing facilities on the one hand, and call for the elimination of an existing bulkhead, or the most of the existing bulkhead on the other hand. If there is litigation in this case, and there may well be, we intend to argue that the board's jurisdiction is limited in the fashion I've just outlined, and that no permit should have been required for the permit for the repair and maintenance of the bulkhead. In the alternative, we would argue that a permit was required only to a minimal extent, if any, for non-vegetated wetlands for which it would be necessary to compensate. What I would call this proceeding, as I've looked at it, is jurisdiction creep. In the very first staff report that Katie Herman issued, there was about 320 square feet of wetlands that needed to be mitigated. That has risen now over the course of 2 years to 1,270 square feet. Why? Why? It's a consequence of their inability to repair the bulkhead and to finish the work on the bulkhead because of the stop work order. So long period of noncompliance and willful resistance, I would say, is in fact inerrant. It has been a period where the SANs have tried repeatedly to meet the requirements. And it's kind of like Linus and Lucy in the football game. You remember that? Where Lucy holds a football, and every time Linus tries to kick it, the football goes up, and he falls on his back. That's the board, that's Katie Herman, and that's the SANs.
I believe it's Charlie Brown.
Charlie Brown, you're right. It is Charlie Brown. Exactly right. Another fan that goes back on this. So I don't think that the characterization is correct of the SANs performance and their attitude. They've tried repeatedly. They've spent a lot of money on trying to comply. They've invested. They had to refinance their home in order to raise the money to repair that bulkhead. They raised tens of thousands of dollars to do that, and they've got other sort of obligations, financial obligations that they still have to meet. As I understand it from the suggested restoration order that Ms. Herman has proposed, it would require the removal of most of the right side bulkhead and the boat slip. It would effectively convert most of the SANs yard to wetlands and render it effectively useless for the family. We believe that kind of remedy is extremely draconian and is unreasonable per se, because as I said, we believe that they should have been entitled to repair and maintain the bulkhead without the need for a permit. Even though I don't represent the contractor, I would also object to financial penalties being imposed on the contractor and on my client. I understand that the position of this board is basically to use the restoration order as a hammer to force our clients to do something that you believe that they haven't already done and that you believe is required. I don't believe that that is the case. Instead of the restoration order that Ms. Herman has proposed, what we were planning on doing is saying, look, the third permit application that was submitted in September, and in particular the engineering that's contained in that application, should provide the basis for the restoration order. And in fact, in a conversation yesterday with the MRC, with Randy Owen and Mike Johnson, they specifically made that suggestion. They said, why don't you go into the wetlands board and make the suggestion that the engineering the third permit application be used as the basis for the restoration order rather than what Ms. Herman has proposed. So what I would like to do is just ask Jim back to answer the issues that I've raised, to address the issues I've raised about what we think is the lack of Ms. Herman's understanding of the third permit application, using that chart that's up on the easel is the one that he would use. So I would ask Jim to come up and make a few comments about the engineering.
Yes. Oh, wait,
That
no,
one or
sorry, the
this
other
one?
ones.
Oh, and I apologize, this is probably small. I'll move the poster board closer to the table so it may be easier to see. And of course, this is our called the September 11th JPA application that we submitted. And we did get comments on October 5th from staff, which I have here. What we're trying to do is to provide enough backfill to save the tree that's at the bulkhead and bring the grade up so that this is no longer a safety hazard for the Sands children. That's what this plan depicts. The areas in the plan, as you talked about, the full jurisdiction, 580, 560, and I can't read upside down, but adds up to 1,200 square feet. That is the total area between mean low water and mean high water across the entire property. We're not proposing to disturb that much across the entire property. What we are proposing to do is to do some limited fill against the bulkhead to restore it. And then we're going to compensate for that area with a marsh area. Of that marsh, so the marsh is total marsh area is 484 square feet. That's the entire area. Of that 484 square feet, 402 square feet is above high water, mean high water line. So that can count towards compensation. The fill area is 393 square feet. So we're compensating an area equal to the fill area. The analogy that I talked about with the Sands, if this were a large piece of property, extended piece of property along the river, and the board's jurisdiction was, say, a full acre of intertidal marsh area, and an applicant came in to disturb a few square feet of that, you wouldn't require the entire acre of wetlands to be mitigated, would you? So in a nutshell, that's what we're proposing. As Craig said, we had hoped to be able to present this as an alternative to the restoration order as a restoration, let this serve as the restoration order.
Jim, may I ask you to explain why you think Katie's numbers are wrong?
Yeah, so in the October 5th letter, there's a mention of 888 square feet that we're proposing to make. We're not proposing that. We're proposing a total of 484. And of that 484 square feet, 402 square feet are above the mean high water line. So it's a total of 484 square feet. We're certainly not disturbing 1,200 square feet. That's the area on the property. As the board member was discussing, that's the platted area. That's the total area on the property. All we want to do is provide backfill on the bulkhead in order to stabilize the tree area and make the area safe for the Sand children. Currently, it's not safe. I walked down there today with Mike and sprained my ankle. We want to just get it restored for the Sands. Again, these areas are post disturbance. We maintain that before there was disturbance, it was less of an area, and I think the aerial photographs that the chairman referenced indicate that as well.
Anything else? Yes, Mr. Chairman, I'd like to ask Justin Sand to just give a quick few comments on what the impact would be on the implementation of the restoration order, which I understand would result in the removal of the bulkhead throughout on the right-hand side of the property, and would basically cause convert a lot of the property to effectively wetlands.
Yes, but if you guys issue this against us, I mean, this is, we bought this property, we saved that money, we refinanced our house to be able to pay for this. Luckily, our contractor woman stayed with us through this entire process, and engineer and through attorneys and through property line, boundary line changes, to having to deal with my own community who owns in front of my property. That's privately owned by our community. We pay hundreds of thousands of dollars to maintain that channel. It was just dredged before my wall was deteriorated. They dredged the entire channel that we just had done, including we were misguided by different people that have now retired, telling us to do certain things with the permit. We've been trying to go every which way with the permit and continue to send everything that we can so that we can mitigate this and get this passed. We don't want to be drug out through this. It's been 2 years of our lives, our kids, and we can't even go down to the bottom of our property and enjoy it. Our boat, we can't put in there. If we had to take this out, this, everything, my tree is already deteriorating to the point where it's almost dead completely. And I'm hoping that we can still save it. And that's why we could not, we told you we could not sign that first permit that had huge holes cut into it. Not only would it make my neighbor, his property, that wall erode, but my tree would fall down and go into the water. It very well could, because it's been left for 2 years now like this. And we're just trying to maintain that tree, trying to bring that health back. But the arborist have paid for a separate report, to give you a report out there. That's why we said, well, we'll even chop down the whole left side and make wetlands. We had no problems with any wetlands. We even, in the original report that was approved, and the permit that you guys approved was 340 square foot. It was not 480 that we were proposing to plant for you as a wetlands that wasn't there before. You can look at aerial photos. This was a man-made channel that was created in 1960 for a waterfront community that was made that was never a wetlands ever. It's been privately owned and maintained, hundreds and hundreds of thousands of dollars by our community and our HOA to pay for this to be a navigable channel. This will create everything falling into our channel, make it not navigable, like two houses down from me, so they don't have a wall at all, and they've lost their entire bottom of their property. Entire part of their property has been dredged multiple times out of our channel, and we have to continue to pay as we do that. Financially, it's a burden that everybody is wishing that I had. We've had multiple testimony from all my neighbors. Not one has opposed. Every single person wants this wall to maintain, not only the tree, but everything on my property from going into this channel. It will not maintain. It's just too narrow and too shallow of a channel. Everything will erode. We get water on the other side of our bulkhead because the water keeps rising, and every single property along every waterfront property goes over the top. So there's crap there. It wasn't there before. It wasn't ever there before. It's always dirt, it's always grass, and maintain that forever before we even bought the property. We're just trying to get through this. And that's why we put another permit September 8th. Saying, here, take this. And you keep waiting for guidance. We waited till the last hearing that we had with you guys. So now, for any guidance, we had no guidance from anybody, reaching out constantly, week after week, with nothing from the county, nothing. The DMRC, nothing, no guidance. County attorney, we've been CC on every email. Jim Beck has been every single email. We've been reaching out. We've been trying to do everything we could to keep our property. That's why we had to even hire an attorney now, $3,000 to come here and say, please don't take down our wall, which we need to maintain our property, which we are in Fairfax County as a waterfront home, not a water view home that has a boat slip. That's why we bought it. Our house value would go significantly down if we had to take this down. It would be it's crazy to our property value. So that's what I have to say.
Mr. Gorey, we've taken testimony from people opposed to the restoration hearing. I feel we may have people that have more to add to this and some that may feel differently.
It's not a public hearing, it's a hearing on the restoration order. The landowners and subject of the restoration order have the right to testify and present evidence and testimony as to why or why not the restoration order should be entered. Members of the public are not permitted and not authorized to comment on the restoration order.
Very well. But I would like to ask staff to respond to the statements that have been made. Catherine, can you do that, please?
Sure. So from staff's perspective, there's been several, if not think I counted earlier today, 3 or 4 written requests from the applicant to provide the full Wetlands Board jurisdictions on submitted drawings in the past 2 years. The complete depiction of the board's jurisdiction, full jurisdiction, has not been provided until July 10th, 11th, 2023. So for 2 years, that is why past 2 applications have been deemed incomplete in my perspective, and that was written into the staff report because I did not have complete information. I did not have the board's full jurisdiction on a design that was to scale based on the vegetated wetland plants landward of the bulkhead. Now, in terms of the mitigated area, there seems to be, I will acknowledge there seems to be a difference of opinion on which wetland plants exist where. The agent who created the proposed design that's shown here shows that there's only one section of vegetated wetland plants. I personally observed something different, and we've spoken about that. And I showed an image of that during the public hearing for the second application that we heard on June 10th, June 6th. I can't remember all the dates, 2023. So I stand behind the wetland plants that I saw at that site visit in April 2023 that I referenced in my staff report for the June 2023 public hearing. To that end, I have not received any additional information from the applicant providing different scientific information, scientific fact-based information showing otherwise related to the extent of vegetated wetland plants. And therefore, I wrote the memo that I did on October 5th, based on the information that I had at the time, which is where the board's jurisdiction is believed to be. I've consulted with VIMS. Again, they are the scientific, I don't know the exact phrase, but the scientific arbiter within the MRC's guidelines of questions and points around what of vegetated wetlands. And so with that consultation and that information, I wrote the memo that I did that I sent on October 5th.
So if I could indicate the first application, staff estimated the tidal wetlands at a much lower number. But I believe in that first application and the permit issued, the permit indicated that the amount of tidal wetlands needed to be confirmed before moving forward. So while the staff report did estimate it, we never had a number, which we typically would have. We got that number in July. That number totals the 1,270 some square feet. Does this application demonstrate that amount of tidal wetlands?
I think my concern has always been, my understanding is that 1,200 is the entire property. And my concern has always been making very sure that I'm not overstepping my bounds in jurisdiction.
I understand,
And
but the staff has asked for a confirmation of that area. It's been provided by the applicant, and that's the jurisdictional wetlands that need to be restored. What's
we
that
now
going to
have,
change, John?
we now have a stamped blueprint from an engineer licensed in Virginia stating that number is not accurate. I place a very high value on it.
I'm sorry. We've already had another stamp drawing saying that amount, and it fits with what was presented there.
But
I'm not saying that we can't resolve this going forward, John, but what I'm trying to point out is all the things that have happened here are a result of willful resistance by the applicant. This is a long, long history of willful resistance by the applicant.
I object, Your Honor. Mr.
I'm
Chairman.
sorry, I
believe
will,
that's incorrect.
I understand your objection,
That's a
but
gross characterization.
but that is my characterization. I will take that characterization. I've met personally with the applicants, and there is willful resistance to moving forward with the BIM's recommendations.
But
So so I'm going to stop, but I think we have progressed forward, but we do not have an application in front of us at all, because staff hasn't been able to move it at all, because we just very recently found about these correct areas. And what's being proposed has not yet been resolved. So I'm going to stop there, and John, go ahead, jump in.
I mean, I understand that the numbers have moved around, but I have not, I think since the beginning, since I joined, my question has always been precisely where is the boundary? And I do not feel like I have had either an engineer or lawyer give a solid answer. Here is what the law says. I've heard a lot of opinions from them and from the board and the staff, but fundamentally they do not set the jurisdiction. The laws of Virginia do. And I want to make very sure I'm sticking to that. In my career as an IT architect, I have seen much best practice that is wrong. There's common belief that enters into a field and is wrong. You always have to go back to what is the law say? What is the standard? And what I'm seeing here on the engineer's diagram and in the law, and I re-looked at that language, it says the lands on the site upon which it's growing the species. Well, the lands on the site, according to this engineer's diagram, is on the north side of Wetlands. And it is a much smaller area. Now, there could be some discussion about how big that is. But again, I place a lot of weight behind the fact that an engineer is putting their stamp and career on this diagram. That is more weighty to me than anything not coming from an engineer or an attorney. So I really can't vote on something that says our jurisdiction is the entire plat perfectly ending at the property boundary when I don't believe that's what the law says. I'm not willing to vote on something that I think exceeds what I vote. Because I don't think that's balancing the private and public interest.
My understanding, you'll have to correct me on this, is that VIMS is the definitive science for the wetlands board. Am I
Yes.
correct about this? Yes.
But they don't set our jurisdiction. They can't because they're not attorneys, they're not legislatures.
They are
cannot
the
do that.
science that undergirds all of this stuff.
Best practice, not our jurisdiction.
If they say that this is the way it is, you can throw as many architects at it as you want, but it's not going to change the science.
If IMS comes back and says mean low water line is at the bottom of their house, that would not hold weight. That would lose, because they do not set mean low water line and engineering firms do. That if VIMS can talk about best practices for maintaining a living shoreline, they cannot legally define what our jurisdiction is.
John, I'm misunderstanding you, sorry. We have a stamp drawing from the applicant, from the engineer, that indicates a total jurisdictional area of 1,207 some square feet. Do you disagree with that?
That is not my recollection.
They
My
said-
recollection is they marked the low and high water.
No, they put the data on the table. The data on the table indicates 500 and some square feet between mean low and mean high, and another 700 and some square feet between mean high and 1.5 hundred.
And that's for the entire property. That's not what we're disturbing.
It's what's disturbed.
No, that's
It's
not.
what was in your survey.
That's the entire property.
That's on the entire property. What we're proposing to disturb is the.
It's already disturbed.
You're now arguing with the
No,
engineer.
I looked at the drawing as well. The jurisdictional area is the 1,200 square feet. It is. So, John, you can disagree with that fact, that's
You
okay.
cannot make that argument without arguing that the property owners on both sides also are now vegetated wetlands. It does not perfectly undeveloped.
Say they weren't vegetated wetlands.
But they're not here. This isn't a restoration order about the adjacent property. This is about this parcel,
And
this property, and I've been there. There are wetlands on both sides of the there.
Then why don't we have a diagram stating where a county attorney or engineer has determined our jurisdiction to be? That's what's.
Because we have a
a
submittal from the engineer that shows the square footage right
Yes.
on the drawing.
And I'm looking at it, it says 5 square feet of vegetated wetlands.
No,
No,
that's
that's existing today.
This is stamped by an engineer.
John, are you arguing there's only 5 square feet of vegetated wetland?
I'm arguing that a Virginia engineer has stamped this diagram stating 5 square feet of vegetated wetlands. So if he is wrong,
Okay,
that is a problem for him, but we need somebody who is an engineer or an attorney to say that he is wrong. And until that point, I cannot just dismiss this.
okay, John,
The engineering stamp that he provided means something legally in Virginia.
so
It means I have to respect these low and high water lines as accurate.
John, I'm not going to disagree with you. Your opinion is yours. I'll leave it to the board. We have from the staff, from the submittals, that there are 1,200 plus square feet of vegetated wetlands, and we do not have an application addressing that. We have an incomplete application.
So what happens when the
So if I
staff
may,
disagrees?
this is not about what was presented here. It's about whether we're going to order a restoration hearing and then work this out with the applicant, face to face, as we have proposed.
That is very relevant to this.
Yes, John, you can attend that meeting, and you can be there and make your case with that meeting, like any other person that wants to do it. But this is the restoration, and we do not have an application that staff can advance. So that's the reason for doing this. And
Yes,
I think that I'll leave it at that. So any other discussion from the other board members?
I'm just curious, with this, the new application in September, did they provide a wetland delineation as it stands today?
No.
Well, their wetlands delineation is the
No.
dark green.
No, there's a report, there are data, there's soil,
There's stamps.
there's professional wetland delineators, and we needed to, we don't have.
I based that on the
we don't have
elevations.
one.
We
Okay,
did not do the vegetation analysis. That's based on the elevations that are out there. And again, we're not disturbing that 1,200 square feet, and that 1,200 square feet did not exist prior to disturbance of the area. And 2.5 years ago.
If I could, Klein.
well, nobody can prove that.
Again,
I know.
So-
So nobody
That's
can
why I
prove that,
said-
unfortunately.
What's on that plan is based on my survey from a year ago this week.
Do you have, here's a question.
Yeah.
Oh,
Go ahead.
I would like to understand, based on this drawing, where the limits of the original disturbance were. Do we have that on anything?
I think we do.
On the
On that
original
first permit?
application? On the first permit application?
I think we do. I think it's the drawing that Catherine showed earlier.
Okay. I'm just
It's
trying to
the- it's the
determine if
disturbed
the,
area.
the mitigation or whatever it is, disturbed area, we don't know.
So if I could I say something? So there's been a conversation about disturbed wetlands here. Nowhere in the letter, for Wetlands Board members' knowledge, nowhere in the letter that I sent on October 5th did I say disturbed wetlands. I am trying to communicate from a scientific and ecological perspective that the board's jurisdiction extends from mean low to the 1.5 times the high tide range. And that therefore the associated habitat and ecosystem extends to that space as defined by their design that they provided. I do not identify disturbed wetlands in my letter, and I don't believe that, I don't know, Jim, I'd have to look at your image again if there's a discussion of disturbance, but
Yes, and then that was the point of this application is this 300 and just short of 400 square feet of disturbance where we want to backfill the wall. And to compensate for that on a 1-to-1 basis with no net loss, we're proposing more than that over in this corner with an aquatic bench.
Okay, that was,
That's it. So I think we stand here with a motion to approve the staff report with the one modification. We have the applicant indicating that they think they have proposed something that's adequate, but we don't have a complete application to approve tonight. We have a restoration here. Any more discussion about this?
So then procedurally, can we do anything with this? No.
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 We'd have to do that. We'd have to have an application in front of us, which, as you recall, when we made the motion to have this meeting, the whole purpose was to move that forward. And so that's where we are.
Mr. Chairman, with all due deference, there is an application filed. The only thing that you have in front of you is the engineering. But there was a complete application filed, which Katie Herman declared incomplete because she disagreed with the calculations, but it was complete.
I don't want to shut this off until everybody thinks they've had their say. Any other statements from the applicant?
Well, just one point. The alternative is, there are two alternatives that we have proposed to you. One is defer action on the restoration order and take up the completed application, which is complete, and schedule it for hearing and for consideration. The second thing would be to take the engineering from that application and substitute it for the restoration order that Ms. Herman has proposed. Those are the two alternatives that we're suggesting.
Defer action on the restoration order and set it for the same day as public hearing on application number 3.
We could. I will speak for myself.
What's the timeline on that?
I will speak for myself here for a moment. We've had multiple meetings, multiple hearings on this. Moving the restoration order this evening does not slow down the application at all. It allows it to proceed. And it gives us a deadline. It also forces the requirement for hiring a wetland specialist, which we do not have right now. And it is in compliance and accordance with the 1991 BMRC guidelines. So I will speak that I think I will personally vote for the restoration order. And I view that the way to move forward is to pass this and then work on the application as we discussed here. And in particular, require a meeting of everybody to get in the room and pound this out together with all the professionals involved, which we have not been able to do. So, John, you look like you want to say something else. Go ahead.
Yeah, if we imposed a civil charge tonight, would that, like, let's say we went with minor, would that exclude the option later of that escalating?
So the civil charge is not required for 18 months. We're not asking you to pay the civil charge now. And I'm assuming, John, that if we had an approved permit, we would waive that.
I understand that. I just want to make sure I understand the options. I would have a very hard time voting on this measure with it at significant impact level, even under the understanding that probably will never be paid, simply because it seems improper. If we have the ability to escalate that, if the impact grows, I would push for us to push these to minor and then escalate. Because I just can't vote for, I don't think it's the correct impact level, and I don't agree with forcing the tear down of the boathouse, which is at the crux of the issue.
I'm not calling for the tear down of the boat
That was point number one. The removal of existing structures.
that were built after 2015.
Which would remain the removal of the current boathouse.
No, the boathouse was existing in 2015.
It has been replaced. The roof fell and it has been replaced. This is a new boathouse. And so we would be arguing for the removal of a structure that does not impact the wetlands.
It's true.
And I can't, and the piers appear to be allowed if they're at a significant height. I think it was 4 feet. But there's just a lot of too many things here for me to vote yes. But if it was lowered minor and the boathouse was left, yeah, perhaps to move it forward, I could be okay with that.
John, could you make a motion?
Well, the motion is dismissed. At this point, I just,
You can make another motion, John. Go ahead, make a motion.
I would raise a motion to strike item 1, the removal of the existing structures, as it does not impact the wetlands that is permitted by Virginia law. I would move to change the homeowner impact to moderate.
Do I have a second? I will second this motion. Discussion. I would like to limit the removal of structures to allow the boathouse structures to remain. But the boardwalks and the other piles, I think have to be removed to actually restore the tidal flow. But leaving the boathouse in place, I support that. I don't think we should ask them to rip out the boathouse. And I don't think we're going to get to that anyway, I really hope.
No catwalk. Well, I don't think there's catwalk at the moment. I don't think there
There's
are.
a catwalk on the south
Those are
side.
proposed.
This is catwalk on the
Catwalk on the
On the north side.
on the north side, but not on the south side.
Right.
And it's not, this design, not propose a catwalk on the south.
Right, understand.
We are trying to save the tree.
John, will you accept my amendment as a friendly amendment? All those in favor of this change, vote by saying aye. Aye. Motion passes. I'd like to vote on the main motion now. Those in favor of the restoration hearing as modified here this evening, vote by saying aye or nay. Aye.
Aye.
Motion passes. Thank you. That ends the restoration hearing. We are now on agenda item meeting minutes approval.
Yes.
Would someone like to move approval of the meeting minutes?
You're right.
I was moving to reach the agenda. I'm not sure of the right verbiage, but something along the lines that I moved that the previous meeting minutes be approved by the board.
Do I have a second?
Oh, you got it right.
So, all those in favor? Meeting minutes are approved. We now move to the public comment period. We have a sign up list for public comment. Where did it go? Does anybody know?
Sorry, I lost track of it.
Then we have the-
It's here.
Oh, okay.
Thank
Ah.
you.
all right. Hand it to Katie.
Thanks. Okay. Mark Miller.
As another waterfront homeowner, start to say, I'm disturbed. I'm disturbed because you guys just seem to have an insatiable appetite for information and studies and hire a wetland specialist, hire a engineer, hire all these people, hire attorneys. We are not wealthy people necessarily. I mean, we have our own limits to our resources. And I sure wish you guys would do a better job of balancing public, private, what does it mean? And so, one of my favorite sayings is hold on to another mouse kids. And the fact that in this case, the guy has a bulkhead, he has a reinforced waterfront, and if you read the RIMS guidance, it says living shorelines may not be indicated when they front on canals that are solely for the purpose of navigation. Exactly what we have. Living shoreline may not be indicated in close proximity to deep water, defined as 3 feet within 30 feet, I think, as I recall. He has a lot deeper water, a lot closer than that. So, I mean, this is drug it for years.
And again, I think we pulled off your masters. I mean, all these tens of thousands of dollars this guy spent, years of your time, over 800 feet of disruption, well, 400 feet of disruption, I think I heard. Thank you for the opportunity to speak.
Christopher Morgan.
Good evening, I'm Chris Morgan, I'm here speaking as a individual, former chair of the Environment and Recreation Committee of the Conference Council, current president of the Wetlands Citizens Association, which has properties with tidal wetlands. Full disclosure, I'm active candidate for mountain supervisor, which appoints several members of the Wetlands Board. I've spoken at the previous meetings before. Firstly, definitely thank you for spending your Thursday evening trying to protect the waterways of Virginia and preserving the environment in Fairfax County. If I could just go over here, stop me at any time if this is inaccurate, because this is just trying to break things down how I kind of see what happened here. This is a cross section of the Sands backyard. Essentially looking north and south. Their house is probably over here. It's their backyard. They had their bulkhead. They're right up against the yard. And then this section here is Massey Creek. Any objections there? Now Massey Creek is tidal, so sometimes the water's there, sometimes it's there, sometimes it's there, and it goes up and down, and there's a full moon and a heavy set of rain. You know, it might even be up there. So what they wanted to, but this area.
Excuse me, that is not correct.
What do you object to?
On the north side, there was no bulkhead. It fall down. It's gone.
Okay.
Been gone for 8 years.
So fair enough, though, on the south side. And
On the south side, the land was, you have to draw land, excuse me, you have to draw tidal wetlands landward of the bulkhead.
Might not be able to explore it. So we'll just think of it, this is the south area. So continuing on though, because I get your point, they go to replace this.
Yeah, but you have to show that there are tidal wetlands on the land side.
Can we just talk about the south side?
Not without
But
recognizing.
not where the bulkhead area fell out, but just the south side. This is my testimony, so I'm gonna continue that way. They wanted to replace this, so it gets dug out.
It was dug out prior to being dug
Yeah, I
out.
finished.
No, you asked me to correct something as you went along, and you're presenting something that is incorrect. What you've just drawn is correct.
It was a wall on that side too. Okay.
Yeah.
You're wrong. It was a wall on that left side.
Katie's
as
got
well.
pictures.
You're wrong, Mike. You're wrong.
I'm sorry, that's not the case.
You keep saying it wasn't there, it was there.
Could we allow him to make his comment, please?
There's a wall there.
Proceed.
The pilings, they're still there. They're still in the ground, the pilings, the original ones on that side.
The bulkhead was dug out for the purpose of construction. I think the bulkhead was partially restored. At this point is when the stop order was issued because of the complaint of the backfilling had not been done. And some weeds were in there. The smart grass. To me, this is a simple thing of the family that failed to get a permit to fix what they already had on a community that was designed as a channel waterway in 1960. And maybe some of the bulkheads have fallen down and some have rotted away, but they seem to be just wanting to put what they had. And now they're left with, 2 years later, no backfilling, the expensive process. I mean, to hire all these folks is not free, not provided by the county. And that's the way I see when we really break down this process. So it's disappointing. I mean, it's really appreciate that folks are here that care about this stuff and are nerding out over fetches and VMRC specifics. I'm just really concerned that the impact and the time and resources spent by the county, by the homeowner, hasn't made the waterways of Virginia any safer, any cleaner. Hasn't done anything for the Chesapeake Bay, and it's really painted very honest, painted a bleak reputation for Virginia wetlands. So that's what I would like to say.
Next.
Jim, back, you had your name on here. Did you want to add anything more?
I already That's what I have to say.
Okay, great. Craig Blakely,
Yeah. We're still in.
okay. Glenda Booth,
I want to thank the board for your service. And I know how hard this is, because I was there for a while. But I want to just remind everybody that the Virginia Title Wetlands Law has been in effect since, I believe, 1974. And unfortunately, the legislature had to enact it. And the purpose of it is to protect the Virginia Title Wetlands because they provide valuable ecological services. The legislature amended it twice, I believe, and I believe they strengthened the law. And so this board and this staff, they are trying to administer the law. And they're doing their best to do that. And I think that they have tried working with the applicant, as you say, for 2 years to come to some resolution. And this process and this law and the Fairfax County ordinance is not about navigation, it's not about trees, it's not about property values, it's not about aesthetics. The purpose of the law is to protect Virginia's tidal wetlands. We don't like the law, change the law. But that is what this staff is for trying to do. So I think that tonight they've reached a reasonable resolution. They in fact have given the applicants another chance. And so hopefully that will work out.
okay. Betsy Martin,
Thank you. That's and I also responsibility for that one's board. And I guess I'd like to urge the applicants to sort of seriously listen to the suggestions that they've gotten from a whole range of experts about how they can do their application in different formats and rebuild what they need and protect their property and move on instead of threatening to go to court. Right now, their property is sort of compromised, they are not able to use it, I gather, and plus the erosion is falling into Massey Creek is not being just be put in the bill. And it sounds like the county has actually made a lot of efforts to work with them and make suggestions on how to construct a document that would meet the requirements, and that they haven't provided necessary information. So I hope they change their tactic and, sit down in the same room, like is written into this order, and try to practice and meet their needs. It is important, it's not just part of the reason for this law and for the revision in it is that sea level rise is happening, and it's going to affect all of these tidal creeks, including the one I live in, or North. And it's going to mean that old bulkheads are going to be infiltrated by water. And it's going to mean that new bulkheads have to be designed better so that they're placed properly and designed properly so that they won't immediately become compromised by rising water. And so there's a reason why we really want to listen to what Ben has to say and what BMRC has to say and what the staff has to say, because that's partly why all of the neighbors, there's water coming behind the bulkheads. That's what I heard you say. And so I hope you'll think about the intention to help you arrive at a solution that meets your needs and that also complies with the law. That's all I want to say.
Larry Zaragoza,
I'm going here, still my bathroom again. So, Betsy, I have a different view of things. I have a view of different documents that exist in file for each of the permits that were submitted, land plan audit. And from my perspective, they have tried to be very accommodating. They try to mitigate for the wetlands area is, it was there before they tried to create a wetlands area that's been compensated for with a little bit of extra. You could what was said in the presentation. That is what I think would leads to no net loss. And I think that's what the goal is. We want to basically preserve what you have. However, if we were to pursue the option that we were talking about, where you have a wetland on both sides, you're going to inundate the yard to the south. You're going to inundate their yard. They will no longer have the yard that they bought when they purchased their property. That is what's called takings. You take enough of something and you have to compensate for it. If you put in a code, you're going to have to compensate for it. It's a takings. This is the same thing. You're taking property, private property that are public good. And there's just no ways wrong. There's roads, there's all kinds of other things where it's highly established. And I spent some time professionally working on this with the Department of Justice, multiple federal agencies, states and locals, and that was a couple of years' work. So it's not like I'm speaking without any experience or knowledge on this. So I wanted to make that point. I also want to make the point that if you look at the guidance, it says the restoration of green is appropriate in those instances there's substantial damage to resources beyond that would normally be permitted as occurred. So the substantial damage to resources. What I heard from Sands is there maybe there's a single plant of smart green that was there on the south side. In Stafford, Portland, Benz, from their visit, it was some smart green. I don't know if it was one plant or if it was multiples, but it seems like it was really a minor amount. And so the climate claim that whole area is a wetland is very perfect. And the point that was made by Fred, I think was also really important because he basically said the area that was excavated behind the volcano, that now, it's a wetland now, it's a wetland because of the stockwork order. It would not be a wetland but for that stockwork order. So what sense does that make? As a waterfront owner, I really feel strongly that I want to improve the water. I want to do what I can to make wetlands better. That is very important to me. And see, there's a fundamental difference in philosophy here. I think the way you do it is you do it with education, you get people tools, you do it with the county, you try to get the trash out of the creeks, you deal with all the sedimentations coming down. What we're trying to do here is something that seems to be creating some additional habitat, but it's not doing much for water quality. And it is highly intrusive and costly to property owners. And in the end, I think it's going to alienate people. And you will end up with much less progress than you would if you work more cooperatively and more in line with what other states do. I also want to note that some of the other things I was going to say were already repeated. But I also want to say that I'm very disturbed by processes that the Wetland Board has operated on. If you have a public meeting, material should be made available to the public. If you look at the agenda for tonight's meeting, one of the things it says is for them stuff to go to the BMRC website, for county stuff to go to the county site. So I tried to do that. And what happened? I couldn't get the files. So I ended up calling the county. But this is county. County says only the property owner or their contractors can get access along with county staff. You guys probably have access. I don't as a private citizen. I can maybe call Justin and I'll get with a little bit of, pleading, he probably doing whatever he has. But, it's not only law. Notice, the notices may go off in the paper, but they go off, it's like the notices may go off in the paper, watch 2 times, and they may go send a letter to Sam's. But they are not posted on the Wetlands website early on. The meeting minutes for this body. Only recently were this year's meeting minutes posted. And this is, we're talking about something that really affects their lives. It's a lot of money. And it has implications for the future. I don't see the same outcome as you do. I want to have more wetlands. I want to have people supporting wetlands. I want to see water quality improve. I want a better environment for the future. But this approach, I think, undermines that outcome. It's very, very disturbing to me. And I will leave it at that for right now, but I really hope that this is a project. I was lost, that you just do it. It seems like I would have read the staff report, I would have reviewed it. I would have tried to look at how is the significance determined. To me, it seems like this is a minor impact. I'm not just trying to be objective. And I play devil's advocate on a lot of things, but I cannot, for the life of me, conclude that this appears to be significant in any manner, shape, or form. Thank you.
Justin Sand.
We're trying everything we can, just asking you guys to do the work. There's other wetlands that are before, especially if trading came out of my property after 2 years or a year. So 3 months before Vince came out there, it was dirt, it was grassy, we were waiting for the stop of the border and they're crucial. Vince came out identified, he said, okay, there was found a plant after we left in my property, my neighbor, or we went right in the neighborhood. They're both grass, all they're both grass. They're both on my property, just like any aerial photo or any photo provided, it's always in grass, all the way to back there. One on the left side and the right side. On the left side, there was serious deterioration, which is why we saved that money and refinanced our house so that we could pay for a bulkhead replacement repair and shifting in the exact same footprint that it was. So we could have our old boathouse and bulkhead, which is what we bought when we bought the house. This is not cheap for me. This is not easy. I don't want to go to court because that costs me even more money. I'm actually financing more money. It's a financing burden for me and my community. Anything that happens to my bulkhead, if I have to move it, my tree falls in or my sediment goes in, helps the Chesapeake Bay, let everything off my property fall over into the water. That's $100,000 worth of dredging our channel, which is not what we want. That's not what the community wants. That's not what we want. We are willing to work. We're willing to do. After we are just reducing it, we probably way over the amount. The original 320 square foot, which we were like, that's a lot, but we were willing to do it. We were excited about it. We were excited about planting the wetland plan. My wife wanted to do it. We said, we welcome to it. They were just asking that we want to save the tree on the right side and backfill when it was. We had to pull it back when we built the wall, so nothing went into the waterway. That's what we did. Otherwise, it wasn't there to do. There was no gap in my wall. We were comparing, taking pictures of grass and dirt all the way to the wall. You need to be repaired and replaced. That's what the law states. It says repair, replace the exact same footprint. You stand into a new button. The code says you put a new wall. You can repair and replace in that area in the wetlands. And so if there was wetlands planted, what's party, won't plants the new stuff. We're willing to do that. We're being willing. We're every time we keep being willing to do something, we're asking you guys to do your own well. There wasn't, there's no one of my entire waterfront, entire community that was created in the waterfront community that has wetland plants like this on our property. We didn't buy our house like this. We didn't have wetland plants. We had photos when we bought our house. We had photos all the way back. It wasn't a wetland. We're willing to plant those wetlands, but you guys don't seem to be reasonable with that. Like 400 and something 80 square foot of wetland, and that's not enough. I want 1,200. That's not reasonable. That's insane. That's absolutely taking my property away from me and usability of my property. If I told you that it was 1,200 square foot of your property, you'd probably say, no, you're not doing that. And that's crazy. Now that forces me. I don't want to go to work. That forces me to have to go to work now. This is crazy. Just be reasonable. That's all we're asking.
Thank you.
I had Brad Martin as a maybe.
I'm a yes now.
Okay.
So I'd like to thank all of you. And this lady over here made a pretty good point. And I was thinking Martin as well. She said that the bulkheads need to be designed and built better than they were. That's exactly what the Sands are trying to do. They're trying to put a bulkhead in the same spot as the existing failing bulkhead, which Virginia code states there is no permit necessary for that. They keep saying Vince came out, found one plant after it was excavated. Mr. Morgan was correct. Justin has pictures, Katie has pictures. It was dirt and grass all the way up to the bulkhead. When it was excavated back, they stopped work order. 3 weeks later, they found one plant, smartweed. They keep talking about VIMS. Well, the science was challenged by Mrs. Simmons in this building and in a different building the meeting before. She put the case together, VIMS was wrong. VIMS, as this guy said, it's too deep and too narrow for a living shoreline. That's true. If any of you have ever installed one, you would know that. If you've ever dropped a rock in the mud, you know that it disappears. Can't do it in this place, period. No question about it. Can't be done. Anyway, back to the VIMS thing. Where are they? They don't show up at any of the meetings. They can't argue their fact because they know they're wrong. One plant, smartweed, which Livia says found is indigenous to the entire state, not just the wetlands. Real simple. This should be approved. Then we go, well, let's all sit in a room together. Well, we tried that twice. A certain member of this council wouldn't let anybody talk, wouldn't let anybody discuss it. Mrs. Sands said, tell me what to do, I'll do it. Everybody said, no, see you later, we'll go to the restoration hearing. That's all I have to say.
Thank you. Anything else?
That was the extent of the list.
All right. I'm going to close the, does anyone else want to make a statement?
Yeah, I would like to say something.
Please state your name.
And I believe that there's many customers that we have. We are having the same problem with Charlie. She doesn't record emails, or sometimes she said the customer, you're to receive the payment probably in 2 days. And I have emails of that. I can send it to you if you like. That's not something I can say. I mean, even I send emails to her, she never replied to those emails. And I have proof of that too. I had to even include the Sound family in an email for another customer, that way she can reply. I don't know why, but it's not good.
Before further comments, I'm going to close the public comment period of the meeting. Before I close the meeting, would any of the Wetlands board members like to discuss anything else? We do a public meeting so we can discuss openly anything that you have on your concerns.
Are these files open to the public? I was kind of curious about that.
Yeah, so I've been posting things to Plus and I was not aware that people were having issues getting to them. I haven't.
We have direct links to it, but I don't know, like, how would you get to it if you did?
I'd provide you guys links to the VMRC website, which is the same information that's available to the public. Their website is completely open to the public.
There's some information that is not on the VMRC website, but it's only on your site. And you give me some examples, and that's why I went to the Plus system.
Right, so tonight it is the first night I'm hearing that members from the public haven't been able to view things from the Plus site.
And I told how county staff who manage the Plus system.
Okay.
I explained the situation to them. I told them about this hearing. I recommended they consult with the county attorney and you guys. I said that this is something where there's an obligation to make this information public.
Okay, this is great to know. And I've already sent an email. So I will run that down too and make sure that it's more available to the public. But the Wetlands board members have been receiving the same links, especially to the VMRC website because they catalog everything that's public information. So
You guys should include all correspondences with applicants, any staff reports.
I think VMRC posts information related to permit designs, the approved permits, correspondence back and forth with comments. That's up to them though on what they post, but it is more of it's a full complete case file. And I think they're directed to do that as part of the joint permit application process.
I would say I'll use the VMRC site. It's not the most friendly, but it's all there. Anything else anyone would like to discuss? Hearing none, I'm gonna close out this meeting. Thank you, ladies and gentlemen. Appreciate it.
I'm wondering, good job, Katie.
I'll turn the